It says I'm disabled.
Oh, let me go ahead and
Participant.
turn that on real quick.
Sorry, Your Honor. There it is. All right, Your Honor. Well, the first element, Your Honor, is that there is a valid existing agreement between the parties. And here, Your Honor, is our Exhibit A1, which is the executed commercial contract for unimproved property that the parties executed in August of 2018. Here, Your Honor, the parties agreed, defended, in this case, Your Honor, defendant Abdul Hussein agreed to purchase my client's property at 9202 and 9212 Sain Road in Dallas, Texas, for the total sales price of $650,000. The parties also agreed. That Mr. Hussein also agreed that stated that he was going to pay for the sales price in cash without any financing, Your Honor. In addition to that, Your Honor, Mr. Hussein deposited earnest money of $21,750 with Capital Title, which Capital Title still has today, and which it still holds in trust. Mr. Hussein also agreed to buy the property in its present condition, as is, where is, and where it's located. Let me just get that over here, Your Honor.
I got it. Let
you.
me hear the response.
Your Honor, as you know, you've heard many motions in this case. We have a scheduling order that sets forth deadlines that all lawyers agreed to, sign, submitted to you, and that you also signed, Your Honor, holding us to these deadlines. This motion is untimely, Your Honor, in that it is over a year after your deadline in your scheduling order. If the court will recall, we tried to amend our pleadings back in October to add some affirmative defenses to their claims. The response from plaintiff's counsel was they objected and they moved to strike my pleadings, the amended pleadings, because it was in violation of the scheduling order. And the court agreed with that. And there was an order entered on October 23rd, 2020 by you, Your Honor, granting plaintiff's motion to strike as untimely, striking my affirmative defenses as being untimely. So just in the initial phase, we would ask that this motion is over a year after the scheduling order, that it just be denied on that basis without having to get into
Ms. Ahmed, response?
Yes, Your Honor. Your Honor, plaintiff's counsel conveniently leaves out the fact that this motion for hearing, this hearing was originally set on January 13th. And at that time, Your Honor, as you know, this case was inadvertently administratively closed. And so, Your Honor, you actually decided to continue this case to avoid any issues, any procedure out of abundance of caution, you stated. And you actually instructed us to go ahead and reset this motion, which we did, Your Honor, which is set today, and to provide everyone notice, which we accordingly did. In addition to that, Your Honor, the scheduling order that defense counsel that refers to is actually an old scheduling order. And in fact, that scheduling order has been superseded by the court's recent trial notice on January 24th, 2022. And in that, Your Honor, it states that completion of discovery, presentation of pretrial motions, and other matters relating to in preparation for trial are governed by the Texas Rules of Civil Procedure. And Your Honor, that even if you look at the prior scheduling order, it simply says that all motions, it has the standard Dallas County language where all motions have to be filed and heard 30 days before trial. Your Honor, this motion is still in front, it's filed timely and is before the court timely because we are still outside of 30 days before trial. In addition, Your Honor, resetting trial nullifies previous deadlines in prior orders. And that's according to Killam Ranch Properties Limited versus Webb County. It is an unpublished case, but it is 0408-00105 CV 2008, Westlaw 4958452 at page 4. the same ruling is also in JG versus Murray, 915 Southwest 2nd, 548 at page 50. It's a Texas Corpus Christi, it's a Corpus Christi Court of Appeals case from 1995. But even then, Your Honor, so Your Honor, for this reason, it's timely before the court.
Can I address that briefly, Your Honor?
Yes.
At the time the motion was filed, Your Honor, your scheduling order was still in place. At the time this motion was set, your scheduling order was still in place. Counsel set this originally, her motion, 2 days after our trial setting. And if you look at the scheduling order, Your Honor, it's very clear that it refers to our trial setting of October 20th, 2020 in section E. And I'd go back and just refresh the court's memory. This is a scheduling order that counsel for the plaintiff prepared and had both of us defense counsel sign. Section E, Your Honor, is very clear that she drafted dispositive motions will be heard no later than 30 days. It just says of trial, but I think she meant to say before trial. But it refers to the October setting. So, Your Honor, when they filed this motion, the case was not dismissed. Otherwise, I guess there wouldn't be a motion. The case was on file. The scheduling order was effective. They set it 2 days after our trial setting, but the scheduling order was still effective and the case was not dismissed administratively. And second point, Your Honor, 35 years of learning procedural law from Professor Dorsanio at SMU is when you continue a trial, all of the settings remain the same unless we come back to you and we get permission with an order to extend the deadlines. That's, from my understanding, black letter Texas law as opposed to what counsel was saying. So the motion should be denied without even having to get to the merits, Your Honor.
Again, Your Honor, plaintiff's counsel hasn't presented.
Explain to me what happened exactly. The case was closed inadvertent. Explain what happened there.
Sure. Yes, Your Honor.
I generally agree with Mr. Hamida, but what happened exactly with it being closed?
Sure, Your Honor. So back in November of 2021, the third party actions were, they were settled and the parties were, and the third party defendant which is Ready Real Estate and third party plaintiff submitted it should have been a partial dismissal order with prejudice, but unfortunately they didn't state that. They did not state that in the proposed order. And so once that was signed back in November,
inadvertently closed by the clerks. And
exactly.
Was that closure after the deadline for the dispositive motions?
It was before the deadline, Your Honor. And that's why we filed a motion to reinstate, which was also heard on January 13th.
So let me make sure I'm getting this correct. So there was a deadline to file this or to hear dispositive motions. When did that pass?
Your Honor, I believe, well, again.
Mr. Hamida, when did that pass?
August of 2020, Your Honor.
And then
No, Your Honor.
When did this issue with this inadvertent closure occur?
November of 2021. A year
Honor,
later.
After that date.
Well after it, Your Honor.
Your Honor, the court has reset trial 2 times after this previous scheduling order.
Have I issued new scheduling orders?
No, you have not, Your Honor.
Okay. I'm going to find that this is untimely and when are we set for trial on this?
We are set for trial
I'm sorry?
on April.
I'm sorry. Go ahead.
Go ahead, Mr. Hamida.
April 26th, Your Honor.
April 26th. Okay, guys, thank you so much. Just give me an order on this. Go ahead and, Mr. Hamida, go ahead and prepare this. You can put that it's untimely motion. It's heard on March 7th, 2022. Put that at the beginning and go ahead and share it with Ms. Ahmed. And we will see you guys next month at trial.
Thank you, Your
Thank
Honor.
you, Your Honor.
You guys.